This is the Broaddus case, and please don't mention, I give you instructions here, please do not mention the names of any minors or any victims or the names of, well, we don't do witnesses, but I guess we probably should. But at any rate, I don't think this is relevant here, but at the same rate, I like to say it each time because we want to make sure we don't forget for the case that does come up, because we will be putting this on our YouTube page and it will be accessible to the public. Also, please keep your voice up, and I'm bad at that, so I'll try to as well. And please stand behind the podium since we are recording. And my understanding from our bailiff is the appellees do realize they have to split their time, so if you let me know what you would like to do.
Yeah, we could throw, reserve 2 minutes for the Department of Jobs and Family Services.
Okay, that's fine, thank you. You may proceed. And would you make sure you say your name, and then also who you're representing, but also, do you want to save any time for rebuttal?
I would like to reserve 5 minutes for rebuttal.
Thank you. You may proceed.
May it please the court, my name is Sarah Wiley and I am the attorney for appellant Karen Broaddus. We request that this court remand this case back to the Unemployment Compensation Review Commission for further hearing to fully develop the record, because the decision from the Unemployment Compensation Review Commission is unlawful and unreasonable. The hearing officer in this case failed to fulfill his statutory affirmative duty to develop the factual record and complete the analysis demanded by Ms. Broaddus' request for retroactive benefits. Had he properly developed the record, it would have reflected that Ms. Broaddus was a non-professional employee and thus eligible for retroactive benefits. The record would then show that her job duties included things such as escorting children to the toilets, helping them open their yogurt and cheese sticks, escorting them to and from their cars with their parents.
Because the record's silent, we don't know these things. You're saying these things are true. Are they in the record before us somehow?
They are not in the record, Your Honor. The point of it, the entire purpose of this appeal is to remand it to the Unemployment Compensation Review Commission to further develop the record.
Understood. I just want to make sure there's nowhere in the record I can see what you're saying. This is just your argument today, but it's not your argument as hearing officer aired because they didn't make those findings and inquiries.
Yes. Unemployment compensation law is a creature of statute. It does not follow the typical rules and regulations of appellate law. It is explicitly written in the statute that, unlike in other types of cases, it is the affirmative duty of the hearing officer to develop the record. The hearing officer, not the claimants, has a responsibility to elicit the facts necessary to reflect the claim at issue. The hearing officer here failed to do so. School employees have their own special subset of unemployment compensation. And if a school employee applies for benefits for the summer or between terms period, there are 2 ways they could be found eligible. The first is if there is no reasonable assurance. The hearing officer in this case developed the record and ruled there was reasonable assurance. What he failed to do was step 2 of this 2-prong analysis. Once the hearing officer or UCRC determines there was reasonable assurance, school employees can still be eligible if they are not employed in an instructional, research, or principal administrative capacity, what the UCRC terms a professional capacity, and they are not subsequently rehired. In this case, it is clear in the record that Ms. Broaddus was not rehired, and there is nothing in the record reflecting what capacity she was hired in. Not only did no factual findings occur to determine what type of employee she was, the hearing officer also failed to make any ruling on that matter. The second prong of this necessary analysis is completely absent from the record, and a long line of cases across the state of Ohio make it clear that the correct response to that is a remand for a further hearing and further factual development.
Is there any precedent as to which category of teacher's aide falls into? Because if you look at the definition of instructional capacity, and probably other teacher's aides have for workers' compensation. Do we have any case law that actually puts them into a category? Because if we know she's a teacher's aide and there's some precedent, then there wouldn't need to be more factual findings.
There is no explicit precedent on this particular term, or court precedent. What is notable is that in the Unemployment Compensation Policy Guide, which is the guide that UCRC relies upon to make these determinations, it does list teachers' aides as non-professional employees. So if we were to rely on that, she would de facto be
Say
entitled.
that one more time.
The Unemployment Compensation Policy Guide, which is the internal guidance that unemployment compensation relies upon to make determinations, lists aides as non-professional employees. However, there is not a statutory, regulatory, or case law explicitly on the matter of aides.
Thank you.
Did Ms. Broaddus indicate she was basing her unemployment plan on 41, 41, 29? Or is she based on some other avenue?
Ms. Broaddus was a pro se claimant, I apologize, operating entirely on her own, and she simply applied for unemployment benefits. And the Unemployment Compensation Review Commission then funneled her into the category, the area of 4141.29I, which deals with school employees. And she then responded to their questions, and she entirely relied upon the agency to determine what questions she needed to answer. No questions were ever raised by the agency to Ms. Broaddus as to her job duties, which is the reason she didn't bring them up. However, it is important to note, as is seen in the record, that the UCRC does, in their fact finding, does acknowledge the necessity of determining what type of employee she was. You can see that in the director's file on page 35. That was just never a question that was ever directed to Ms. Broaddus. Further, appellees argue that the issue of what type of employee she was not properly before the commission. That is untrue. It was raised by Ms. Broaddus multiple times. First, when she made a request for summer benefits, which triggers them to know that this is a situation where they have to do the two-prong analysis. And second, when she asked for retroactive benefits. It is important to note that the only place where the word retroactive is ever used in 4141.29, which is Ohio's Unemployment Compensation Eligibility Statute, is in the situation of school employees not subsequently rehired who are given reasonable assurance and are non-professional. Unemployment compensation law, as mentioned previously, is a creature of statute. It is entirely reliant on the statute rather than regular common law rules that place burdens on parties to raise issues or facts. And it was written that way for a reason, because the vast majority of unemployment compensation claimants are unrepresented and are not keenly aware of the nuances of a very technical area of law. The hearing officers for unemployment compensation, on the other hand, this is entirely what they do. They are well aware of what facts should go into, should be determined in making a decision on an unemployment claim. And generally speaking, I have done a large number of unemployment cases over my career at Legal Aid. And in almost every case, one of the first questions asked by the hearing officer is, what are your job duties? If the hearing officer had followed that standard practice in this case, we wouldn't be here, because Ms. Broaddus would have told them that her duties involved cleaning up spills and helping with toileting, clearly not instructional tasks. She would have even told them that her permit explicitly says she is not permitted to engage in instruction. But he didn't ask that standard question, leaving the record woefully deficient. And he also did not answer question 2 of the test for whether a school employee is entitled to retroactive benefits. The record needs to be supplemented to put the facts into the record showing what type of employee Ms. Broaddus was, so that a competent decision can be made as to her eligibility for benefits for the summer period. A remand is required here. If there are no further questions, I will reserve my time.
Thank you.
Good morning, Your Honors.
We'll have your 13 minutes. Go ahead, Christine. Sorry.
Good morning, Your Honors, and may it please the court. My name is Alejandro Cortez. I'm with the law firm of Retzel and Andrus, and I'm here on behalf of the Akron City Board of Education. The issue in this case is not whether the hearing officer applied the wrong standard or failed to make a determination as part of the statutory analysis. The question before this court is very limited. The question is whether or not there is some competent, credible evidence to support the determination of the hearing officer and the commission. In this case, there is ample evidence in the record that Ms. Broaddus, the appellant, was a teacher's assistant employed with the Akron schools in an instructional capacity. Ms. Broaddus testified during the proceedings that she was a teacher's assistant in the Akron Public Schools Early Learning Program during the 2019-2020 academic year. She aided in the teaching of preschoolers.
Counsel, can I stop you?
Yes.
I assume there is a transcript here that
Yes.
we're looking at. Did she refer to herself as an assistant?
She did. Actually, she was directly asked by the hearing officer if she taught kids. And she said she was a teacher's assistant. She did not say no. She did not say that she did all these other duties. She referred to herself as a teacher's assistant. Based on the evidence that's in the record and her own representation to a very clear question. I don't think you can be any clearer when you say, do you teach children? I think that's also pointed out in the appellant's reply brief. They concede that the hearing officer asked her if she taught children.
Yeah, but that's a non-responsive answer, isn't it?
But-
It's yes or no.
It's not a yes or
So
no,
should
but
there
you
be
have,
more-
but you have to look at it in the context of the hearing officer. The court cannot substitute its judgment for that of the hearing officer or the commission. The fact that reasonable minds can come to different conclusions is irrelevant to the question before the court.
The issue was never really raised in front of the hearing officer of what type of employee she was under 4129. She would raise this issue of, hey, I didn't have reassurance because of COVID and who knows I go back to work. And secondly, as I understand her argument, the CARES benefits gave me some benefits I should be entitled to and I should get those. She wasn't saying, wait a minute, I'm not a teacher's aide, I'm a non-professional person, if you will, under the statute, therefore it should apply. So there was no discussion of this on the record as far as I can tell from the record.
Well, I think it's page 98 of the director's file. I think there is an explicit reference from a question from the hearing officer to Ms. Broaddus. What is your position?
I would agree that is in there, and there's the one line answer, she says the teacher's assistant, or something to that effect, and there was no further discussion of what exactly do you do. Ms. Broaddus wasn't saying, I should have got unemployment earlier because I was a non-professional, we need to examine that issue. I thought part of the argument was, this was never raised below.
Well,
Because it wasn't raised below, she loses. Not this was all raised and we figured the answer to that out, it was just, we never.
Well, I apologize, we have a two-part argument. Obviously, the waiver part of it, I think the trial court looked through the record below and concluded that it was not this issue of classification was never raised before the hearing officer and was never raised before the commission. The trial court made that conclusion, but was reluctant to make the actual determination to dismiss the case because it was waived. However, I would posit to the panel that the waiver doctrine applies universally across the board. There is no exception to unemployment compensation cases. There aren't exceptions just because Ms. Broaddus was a pro se appellant.
Is there, in this, there's no dispute that there's no burden on either party at the hearing, though, so.
But there is case law that holds that appellant, that claimants also have an affirmative duty to present the issues to the commission.
Well,
Not in a legal sense, but Ms. Broaddus knows what she does for the Akron Public Schools.
Well, Counsel, I'm gonna interrupt you because we have limited time, so I apologize. But I was gonna ask the same question that Judge Lanzinger did. If there's no burden of proof, how do you waive something? Since you don't have the affirmative duty to prove it.
Well, I think what you're asking is from the perspective of the appellant presenting her case or the hearing officer?
Well, I'm talking, the whole point of this, as I understand it, of this appeal is that appellant is arguing that she did not specifically say which statute she was operating under. She just said, look, I'm employed by the Akron City Public Schools, and I am a teacher's assistant or teacher's aide, whatever she said, assistant, that's what you were saying, she said. And here's the letter, that I received, and I'm entitled to retroactive benefits and unemployment because I'm not gonna be hired again. Wouldn't it be the hearing officer's responsibility to inquire of her as to her actual job duties, so the hearing officer could then make a determination as to whether or not she was a professional or non-professional?
Well, again, I believe that the record does show that the hearing officer did ask her what is her position. That is another way of asking someone, what are your duties in this job? And she did not go into any detail about what she did as claimed by counsel. She clearly had the opportunity to do that.
Was she a 12-month employee?
That I'm not sure.
You don't know if she was a 9-month or 12-month. Do you know if she received compensation during, because all teachers, the professionals, they get their money year-round, right?
Yes.
Okay. And there's no evidence about that either way?
No, I don't believe so. I don't believe so. But ultimately, there was a duty on the appellant to raise these issues as well, to clarify what her job position was. The fact that the hearing officer concluded that she was ineligible for benefits, the inference can be made that he concluded that she was employed in an instructional capacity based on the facts that were before him. Again, this isn't to say whether or not the hearing officer made the right decision. The question before the court, is there evidence, competent, credible evidence, to support that decision?
We're supposed to be deciding also if it's arbitrary and unreasonable as well. So if there aren't enough facts for us to decide for him to come to a certain outcome, wouldn't that be arbitrary and unreasonable?
But I also believe that the hearing officer did develop enough facts to make a determination based on the representations of Ms. Broaddus, based on her lack of any testimony that contradict that she was a teacher's assistant in an instructional capacity. Again, she had the opportunity to present her job duties before the hearing officer. She did not, and based on the evidence that was before him, which is competent and credible, it's her testimony, he concluded that she was employed in instructional capacity.
What do you do with the case law that talks about the hearing officer has the duty to inquire sufficiently enough in order to get the evidence that's required to make the determination?
Again, I would say that in this case, the hearing officer fulfilled his statutory duty. He inquired into what her position was with the Akron Public Schools. Based on the representations that she provided, he concluded that she was employed in an instructional capacity.
Okay, let me ask you this, in regard to the statutory classifications. Do you agree with Palin that it's professional versus non-professional?
I believe that there is a distinct statutory definition for what is a or I think there is a statutory reference as to what a non-instructional capacity is, and I would defer to the statute again. But I do believe that there is a clear distinction between instructional and non-instructional capacity.
So you're solely dividing it on the basis of instructional versus non-instructional instead of professional versus non-professional?
Yes. I mean, I'm using the words that are used in the revised code. I know that the appellate made reference to this UCRC policy guide, but again, any reference to that is not before this court. It's not part of the record. There's no indication that the hearing officer or the commission relied on that type of policy guide in any formulation. So I just think it's irrelevant and not something that the court can base its decision on.
It just seems like there's a big difference between a teacher and a teacher's aide or a teacher's assistant. They're not responsible for teaching the children. They're not legally responsible. You have to have a teaching degree and you have to be licensed by the state of Ohio in order to instruct children, don't you?
I believe so, yes, but she could be, I guess, it's the extent of what the instructional capacity is. Again, there is no explanation of what she did, but that is not the fault of the hearing officer. That is the appellant's opportunity to provide that information. She was given the opportunity to explain her position. She failed to do so. And based on what the evidence that was in the record, the determination was made. Thank you.
Well, he saved you more time. You have 4 minutes and 25 seconds.
I'll try to answer what I heard from everybody. I think I got some answer. My name is Lawrence Snyder. I'm from the Office of the Ohio Attorney General, representing the Ohio Department of Job and Family Services. To answer some things I heard. Judge Stevenson, there was 2 notices of appeal filed in the administrative process. One's at page 46 of the record, one's at page 57 of the record. One is an appeal of the initial determination, one is the appeal of the redetermination that then goes to the UCRC. Neither of those are you going to find, those are the notices of appeals filed by the claimant. You're never going to find in there any mention of, I was in an educational, non-professional capacity. The notices of appeal were requesting that she not be found not to have reasonable insurance, and with an attempt to apply under another program, what's called the Pandemic Unemployment Assistance Program. That is for individuals who are acting as independent contractors. It was very confusing. I would understand how someone would, you hear people getting a lot of money, you want to get in on that money. But her application was under what would be called, very sophisticated thing, regular Ohio unemployment.
So you're saying she didn't even apply under the regular unemployment compensation?
She did apply under regular unemployment. Her appeals, if you look at the notice of appeals, she believed that she should have been found not to have had reasonable insurance, and that because of COVID, because of an order from the governor closing the schools, these are all in the notice of appeals, and that she should have been entitled to her unemployment from the beginning as a result of that. Now, that's all water over the dam at this point, but that's why it's not raised at the UCRC hearing. What's raised at the UCRC hearing, and the very first question is correct, is what is your position? So the question is, how far does the hearing officer have to go if the issue is not raised? Remembering that this is still the appellant's, excuse me.
Go ahead, finish what you're going to say.
Well, if you go into the statute, it's in our brief. While there's no burden of proof, no preponderance, no beyond a reasonable doubt, there's a burden of going forward in that the appellant has to bring the issues before the review commission. And that's shown in the administrative code, which is also in the brief, which is 4146-7-02A, which says that the duty of the hearing examiner is to render a fair, complete decision on all issues which appear to be presented.
Okay, counsel, let me ask you this. With the presentation that was made and so forth, she presented, you said, 2 claims, and one was under the UCRC, right?
No, it would be the regular unemployment statute.
Okay.
That's how her
Unemployment
claim was
compensation.
processed, and I
Okay.
think we all agree that's correct.
Okay, all right. So she came in and said, I think I am entitled to unemployment because I am a teacher's assistant.
Because she was employed in the state of Ohio,
Well,
regardless of her position.
I know that, but I mean, what I'm saying is her argument of going forward, because you said she had an obligation of going forward with evidence. So what was her burden? It depends, I guess, how much you want to enlarge that or narrow it.
Not her
in
burden,
regard.
but to simply state the phrase, I think I'm entitled to those benefits because I'm not, it's not educational. Professional and non-professional do not appear in the statute. Those are internal words used by ODJFS. The question is just about these 10 weeks.
Right.
So,
But I guess my point is, you're saying then that the hearing officer had no burden to further inquire as to whether or not she was in an instructional capacity.
I believe, as Mr. Cortez pointed out, he did several times. And also remember, on an appeal, before the UCRC, the entire record is before the UCRC, including everything that was filed before the director. It's all, if you'll read in the statute, it'll say the hearing officer must consider the hearing and everything that was submitted from the beginning of the application. You'll find references to
I'm sorry. Well, the trial court didn't make a finding that the issue of whether she was, I'll call it non-professional, professional for want of a better way of saying, was addressed by the court. The trial court found the court didn't address it. We designed it in the trial court.
And
Yes.
and you answer this question and you are out of time.
All right.
No, go ahead and answer his question.
So if that's correct, the trial court found, reading the trial court's opinion, the court finds the issue of whether Ms. Broaddus was entitled to retroactive payments pursuant to 41-41-29 was never presented to or addressed by the commission.
Yes,
So
that
if
would
we
be our
were
argument.
to find what you want us to find, that contradicted by the trial court.
Well, I want you to find what the correct answer is, whether it's for me or against me. What I want you to find is, I don't want a decision that comes out that broadens the hearing officer to become an advocate on the behalf of one party or the other. There are two parties to every one of these cases. The hearing officer is impartial. He's not to go on a hunt for issues to
Okay,
raise.
you're out of time. Did you-
All right.
I do have another question. You know, when it uses the term appears to be presented, doesn't that seem to put an onus on him to know what issues to look for? Not that someone has to present those particular issues to them for them to consider them?
Again, I go back to the actual notices of appeal. Those are the issues that were presented, and the issue was in a completely in different direction.
Okay, we understand your position.
Thank you very much.
Thank you. You still do have 5 minutes if you want to use those.
Thank you, Your Honor.
Go ahead.
Thank you, Your Honor. I would have several responses to the presentation by appellees. First of all, they made a great deal out of the fact that Ms. Broaddus's appeals were talking about reasonable assurance. There is a reason for that. She never brought that up in the first instance. Her original denial said she is denied because she had reasonable assurance. She simply brought that back up because it's what she was told was the issue. If she had been told there was an issue regarding her category of employment, she would have responded to that. But no one ever said that that was an issue to her. The only place it was said is in the record on page 35, the documents that were available to the fact finders and to the hearing officer, but not to Ms. Broaddus. They were on notice it was an issue, both because they should know that the law says it's an issue and because it was explicitly in the record. It was never brought to Ms. Broaddus' attention. Therefore, she answered what she was asked. Because she was told she was denied due to reasonable assurance, that was the subject of her appeals. Makes logical sense. Further, appellees were talking about whether there is competent, credible evidence in the record. Saying that if reasonable minds disagreed, the court must uphold the UCRC's decision. That is the standard that applies to questions of fact. There are 3 different ways that courts can reverse or remand the decision of the UCRC. If it is unreasonable, unlawful, or against the manifest weight of the evidence. The reasonable mind standard applies to manifest weight of the evidence arguments. Those are not being made here. Therefore, that standard is not applicable. Further, the only duty that, it is true that claimants have a duty in UCRC hearings. That duty is to show up. If they don't show up, they lose. Once they show up, the code makes clear that the onus is on the hearing officer to elicit necessary facts, not to advocate for any party. No one is saying that he should have advocated for Ms. Broaddus, simply that he should have asked the questions to bring up the facts necessary to reach a conclusion as to her eligibility under the law. Finally, I would say that regardless of whether the hearing officer believed that her saying to the assistant was sufficient evidence to determine she was an instructional employee, that is irrelevant because he never made that determination. There is no decision on this matter. So it simply has not been addressed by the court, even if in the hearing officer's head he thought it was. It was never addressed, and it is required that that matter be addressed by the Unemployment Compensation Review Commission in order to reach a decision in cases like that of Ms. Broaddus. He did not make a determination, and he did not elicit the facts necessary to make a determination. Therefore, it is necessary that this case be remanded back to the UCRC for further hearing in order to determine what type of employee Ms. Broaddus was. If there are no further questions, I rest. Thank you, Your
very
Honor.
much. Thank you all for your presentations here this morning. And the court will consider the matter, take it under advisement, and will issue written opinion that is sent to both sides, or all sides here. And we also will release it on our Supreme Court website, so electronically. Thank you again for your presentations, and everyone have a wonderful day.